A very warm and pleasant good evening to our viewers in Anguilla, Government of Anguilla, Lloyds, as well as those listening via 95.5 FM. We welcome you to another in our series of town hall meetings. And before we continue, let's just invoke God's presence on this meeting this evening. Dear Lord, we ask you to guide and bless us as we go through this important exercise here this evening. We especially continue to seek your protection over this island from the ravages of hurricanes and other disasters. We ask that you provide us with an avenue this evening for education and edification, and that the people of Anguilla may continue to be educated as we go through this process. We ask these blessings in your name. Amen. Good evening once again to all our viewers, listeners. I would like to acknowledge the presence of our retired High Court Judge, Justice Don Mitchell. He has been faithfully with us through this long journey from the districts. The members of the audience, our listeners via Radio Anguilla, and our viewers on gov.ai in Anguilla and Lloyds Live. I begin, as I always begin each of the evenings, with the opening stanza of our national song. God bless Anguilla, nurture and keep her, noble and beauteous, she stands amidst the sea. O land of the happy, a haven will make thee, our lives and love we give unto thee. Ladies and gentlemen, welcome to this, the fifth in the series of town hall meetings that the Ministry of Home Affairs is organizing to solicit the views of the general public on constitutional reform. I would like to state again that in our APM 2020 elections campaign manifesto policy, by way of a vision statement, we stated inter alia that the Anguilla Progressive Movement APM understands that enhancing the foundation of a great society means investing more in its people and empowering them to take ownership of their own destiny. Charting our own destiny means that we have the right to self-determination as the United Nations Charter mandates, and consequently as a people we will have to reach a consensus on a roadmap on how this can be achieved. Tonight we are in District 4, Valley South, broadcasting from the House of Assembly chambers here in the Valley. We want to thank the Speaker of the House for allowing us the use of this facility. In my speech this evening, I will read out the former Chief Minister Osborne Fleming's statement to the UN Decolonization Seminar meeting, which was held in Anguilla in 2003. When we were in District 2, I would have read former Chief Minister and Father of the Nation, Mr. Ronald Webster's letter of 2014 to Justice Mitchell, who was the then chair of the Constitutional Reform Committee at that time. I think it is important to have as part of the national record the views of our various leaders of Anguilla on constitutional reform. And now I present the statement by the Honorable Osborne Fleming, Chief Minister of Anguilla, which was presented in 2003. Since I have already shared some of my government's views on the issue before us, as a good host, I will try and be brief as possible in these remarks so as to ensure that my other colleagues from the territories get a full opportunity to air their views. Some of you may be aware that we in Anguilla are in the process of conducting a constitutional and electoral reform review. The process is still in the awareness-raising stage, and we are hoping that when it is completed, as many of our citizens as possible will share their views on how constitutional reform here should proceed. The members of the Constitutional and Electoral Reform Committee have produced a series of extensive background papers on the various provisions of the existing Constitution, which we hope will serve as a backdrop to modernizing a new instrument. I wish here to place on record our appreciation to the United Nations Development Program and to Her Majesty's Government Fund for Good Government for the assistance thus far in this initiative. As we enter the next phase of the review exercise, it is the view of my government that in any event, several key issues regarding our existing status will have to be seriously addressed if our relationship with Her Majesty's government is to mature, become more democratic, and achieve the level of democratic governance that we seek. In the first instance, my government is committed to the principle of localizing as many positions in the Executive Council as possible, consistent with a general devolution of power to the elected government. Presently, our council consists of a governor, along with the chief minister, 3 ministers, a deputy governor, and an attorney general. While we expect that under the present arrangement, the governor's position will remain essentially the same, we fully expect that many of the powers of the governor should be devolved. In the same vein, we expect that the positions of deputy governor and attorney general will be filled by nationals in the foreseeable future. We are confident that, in the case of the attorney general, this transition will shortly be achieved, but the position of deputy governor has still not been resolved. Once again, this is essentially an issue of human resource development and depends both on the professional development of our people and on Her Majesty's government's acceptance of the principle of localizing key positions. Secondly, I am sure that we would all agree that consultation is a key principle in the establishment of a more harmonious and productive relationship. To this end, the establishment of the Overseas Territories Consultative Council, which meets annually in London and which includes all chief ministers and leaders of government, along with the minister responsible for overseas territories, is certainly a step in the right direction. Although it may be still too early to judge the effectiveness of this initiative, since it has only been in place for 4 years, we think it is certainly a step in the right direction, as it allows political leaders from the territories to interact directly with political leadership in the Foreign and Commonwealth Office, which is the primary point of contact between our elected government and Her Majesty's government. But while this initiative may be positive and is certainly a practical expression of the principle of partnership, it can only have long-term credibility if at some point the principle of partnership is constitutionalized. It is our view that the Secretary of State's right of disallowance and power of orders in council are too one-sided and subject to arbitrary decision. Indeed, they smack of all that is ugly about colonialism. In the spirit of partnership and building on the practical wisdom of the Consultative Council, it seems to us that concrete steps should be taken to constitutionalize a new process of ultimate decision-making in which careful and structured mutual consent would be the basis of a new political relationship. While we proceed along the path of political and constitutional advancement, it is important to emphasize that the people of Anguilla must be fully prepared to meet the challenges and responsibilities of self-government. Decolonization without preparation is not how we wish to proceed. Indeed, my government does not intend to lose the focus on economic and social development that all governments have had since Anguillians made the unilateral decision to build a new society in 1967. I will not delve into economic or social statistics at this time, since you all have copies of the working paper on Anguilla, which contains relevant information. However, I must say that we still have a considerable road to travel before we can feel confident that our economic base is dynamic enough and as diverse as it can possibly be in a small place. Although our tourism economy has grown well in the last 25 years and continues to grow in an orderly and controllable manner, we are still too dependent on this sector and are insufficiently diversified to be self-sustaining. We still have a long way to go before we can feel confident that our health and educational services are at a standard that will provide for sustainable human resource development and efficient health care. On that note, I must say that we are somewhat disappointed with the declining levels of assistance from Her Majesty's government to the social sectors, and in particular the health sector. So we challenge the United Nations and the United Kingdom to work with us in our preparation to assume the essential responsibilities of governance. We invite the Special Committee to visit with us at your convenience to discuss the political, socio-economic, and constitutional development process in Anguilla. We trust that the United Nations and the United Kingdom will expand and accelerate what would appear to be a new spirit of cooperation in finding practical solutions to the issue of global decolonization. And that was the text of a statement by former Chief Minister Osborne Fleming to the UN Decolonization Seminar meeting held in Anguilla in 2003. Constitutional reform is a national exercise, and I am heartened by the fact that in addition to members of the public who have been leaving comments on Facebook and other social media platforms, that we are also increasingly receiving comments sent in by email. To that end, we have received one suggestion from someone in the diaspora that in the Constitution there should be provision for village or district councils. I believe Teacher George Hodge had written on that subject some years ago, so we will have to see if we can dig up those articles. Certainly there are some district-specific issues such as road development, waterworks, farmers markets, knowledge centers, beautification, cultural showcasing, sporting extravaganzas, etc., which could benefit from sustained and organized efforts to address. So a worthwhile suggestion, keep them coming in. Overall, I do sincerely hope that you have been finding these town hall meetings informative and enlightening. While we have been somewhat hampered by the need to adhere to the COVID-19 health protocols, attendance in person have been increasing. And from day one, there has been extensive viewership on the online platforms, Facebook, YouTube, etc. We have also been, myself and my peers, have been guests on Radio Anguilla and Class FM, and will seek to go to other radio stations in the coming days and weeks to get the information out. I am pleased that my ministry has once again been able to team up with the Department of Information Technology, DITES, and Mr. Gilbert Fleming of Titanium Sounds and in Anguilla to provide audio, visual, and streaming for this meeting and the other two meetings to come. I also want to acknowledge the invaluable assistance being provided by my able and capable Permanent Secretary, Dr. Aidan Harrigan, and other technical staff at the Ministry of Home Affairs in ensuring that the town hall meetings take place smoothly. Before I go over to Dr. Harrigan, I just would like to acknowledge the presence of our Minister Sorry about that. I just want to acknowledge the presence of the Honorable Minister of Economic Development, the Honorable Kyle Hodge. And Mr. Hodge, I would invite you to say a few brief words before we continue. Honorable Mr. Hodge.
Thank you, Minister Hodge and P.S. Harrigan, for this opportunity to say a few words. I was going to save this for a little later,
Okay.
but as you were speaking, I just jotted down a few things that I don't think I heard about so far. One of those are fixed date elections. We tend to have long, drawn-out campaigns that further divides us as a people. You know, we get so entrenched in the campaigning and the politics of things. So we have, I believe we've had sometimes a year in advance where you would see campaigns would start. I know in other countries, they have a specific date set for each election, and they have a specified time in which you can even begin campaigning. So I don't know if that is something that you and your team will be looking at some point.
Yes.
So that's just it for now, and it's good to be here.
Thank you so much, sir.
Yeah, all right.
Appreciate it.
Yeah.
I may acknowledge the presence of the Premier, Dr. Webster. So you would like to say a few words before we continue?
Good evening.
Good evening.
I see you did. Yes, good evening. I see you did beauty before age, so that's always good. I expect that the Right Honorable Justice Don Mitchell will be next then. No, it's a pleasure to be here, and certainly as I've gone through the districts with you, I did miss the one at the church in East End, but it is this has been very enlightening for me. I was part of the Anguilla negotiating team back in November of 2019, and when we had the UK negotiating team here. And, it was good to go through it, line by line, the draft that we came up with, or that, former Justice Mitchell and his team came up with back from 2015 to 2017. But I must say these sessions have been more enlightening to me, because you actually hear persons that will impact on state what their concerns are. And one of the things that really resonated with me is the history. And in North Hill, we had a good history lesson there. But it just shows that if our people come out, participate, or participate online in this new normal, or use the email addresses that you put up there, and your able-bodied permanent secretary, it will definitely help as we go forward to get a constitution that we want. Because I think that being the supreme law of the land will help us. And so I continue to be fascinated by how constitutions are constructed, because you never think about it before. It's just, you met it there, but this is a good time when we can actually contribute, participate, and I think that's what the message should go out. You have a chance to make this last for you, for your children and your children's children, to have a document that you can say that I am governed by this, but I participated in it. And that doesn't happen often, and so this is a good chance in our lifetime to make that happen. So thank you again for doing this, and I know as you go to the next two districts, certainly hope that we get enough information that you can draft a constitution, take it back to the people so they can see what the full document would look like, make the necessary changes, amendments, and then, get the UK negotiating team so we can get this done. But again, thank you for all the hard work, and thank all those who have participated, from previous constitutional reform attempts and the current ones.
Thank you. Yes, before we go over, just acknowledge the presence of Mr. Leonard Kentish from District 4. Welcome, sir. and we look forward to hearing from you later in the proceedings. Dr. Harrigan.
Thank you, Minister Hodge, and good evening to one and all. And I adopt the protocol in place. Right, so moving to the presentation. Constitution, so what should underpin? And there's an international legal mandate by way of the United Nations Charter, which states that all peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely determine their economic, social, and cultural development. The United Nations in 1946, by way of UN Resolution 66-1, established lists of non-self-governing territories. And since then, many of them, most of them have become independent, from the large, like India, to small, I guess, like St. Kitts Nevis. The United Nations also in 1960 adopted Resolution 1541, Roman numerals XV, that identified that self-determination can be attained through three modes: independence, free association, and integration. The UN in 1961 established the Special Committee on Decolonization, so-called Committee of 24. And the United Kingdom government, like other administering powers, is obligated to report on an annual basis to the UN on the progress of the non-self-governing territories attaining self-determination. In 1991, the United Nations declared what is called the first international decade on decolonization, with the idea that all the non-self-governing territories would actually become independent by the end of that decade, which would have been 2000. However, that has not happened, and there have been 3 decades. We are in the subsequent to that, the latest being 2021. There are 17 non-self-governing territories remaining, of which Anguilla is one. So, self-determination. There's independence, and in independence, a country gains independence if it has its own government and is not ruled by any other state or country. So, for example, in our region, we have Jamaica, Trinidad, Barbados, and so on, all of whom became independent from Britain. Free association, this is defined as being the result of a free and voluntary choice by the peoples of the territory concerned, expressed through informed and democratic processes, and should permit the right to determine the internal constitution without outside interference. And so, an example in our Caribbean region is the arrangement between Puerto Rico and the United States of America. Integration. This should be on the basis of complete equality between the people of the former territory and the country into which it is being integrated. And examples in our region, in our Caribbean region, are Martinique and Guadeloupe, and their relationship with France. So, Anguilla status of the years. Anguilla was established as a British colony in 1650 and was administered through Antigua. However, in 1825, administrative control was switched to St. Kitts. In 1967, following the breakdown or breakup of the West Indies Federation, the UK established the associated state of St. Kitts, Nevis, Anguilla. And that status represented semi-independent status of the tri-state, because as you know, in the 60s, certainly in the Caribbean, that was the whole wave of decolonization. So the intent was that the associated states would eventually become independent. However, Anguillians, after many centuries of neglect, were not happy with that, and at one of the events to usher in that arrangement, the so-called statehood queen show, it was disrupted, and subsequent to that, the police from the center, from St. Kitts, was sent back to St. Kitts. In July 11, 1967, there was a referendum held, and Anguillians voted, I think, at what is now Ronald Westwood Park, what was then known as Burroughs Park. They voted overwhelmingly to separate from the tri-state. A constitution prepared by Harvard law professor Roger Fisher was then adopted. There was a second referendum in 1969, February 6, 1969, and Anguilla, there was a unilateral declaration of independence, one of the few countries to do that. And a constitution prepared by another American, Jack Holcomb, was adopted. And March 16, 1969, after attempts by the UK sending various high-level officials to mediate, after that did not, materialize, the UK government responded by sending British paratroopers and members of the Metropolitan Police Force to Anguilla. And then that established direct rule from the UK, and formally that was done by the Anguilla Act of 1971, and British rule, direct rule, has been in place ever since, in one form or the other. In 1976, there was a constitution for Anguilla, and among notable arrangements was the provision for ministerial form of government. Then in 1980, there was the Anguilla Act, which empowered Her Majesty to separate Anguilla from the associated statehood. So even though it had happened, that was seen to be informal, and so the formal separation happened in December 1980. And that having been resolved, subsequently St. Kitts Nevis became independent. In 1982, there was another constitution. There was a constitution adopted, and it was amended in 1990 for, among other things, to have the title of Leader of Opposition. And there was a further amendment in 2019. But by and large, what was in the 1982 Constitution holds to this day. Recent attempts at constitutional reform. In 1999, under the Labour administration of Tony Blair, the Foreign and Commonwealth Office published what is called a policy paper on the UK territories. One of the things that it was done was to rename what were then called dependent territories to overseas territories. So if you look in your passport, those of you who have that passport, you'll see British Overseas Territory, then Anguilla. The policy initiative also called for the establishment of constitutional reform committees or commissions in the overseas territories, and that they should make, the territories should make representation to the UK government for constitutional change. However, the UK was clear to mandate, to state that for those territories who wish to remain and have a relationship with the UK, then it would be under certain parameters. So, for example, the UK was not willing to entertain free association with the UK or integration with the UK. However, countries could also choose to opt for independence. Okay, so constitutional committees, there was one in 2001, and we had Mr. Carty, David Carty, last week in Road North. He was the chairman, and he gave some insights from that experience. And as he said, he was disappointed that they were not able to really do anything. Well, they did a lot of work, but no recommendations came to fruition in an organized form. In 2003, the United Nations and Mr. Carty indicated that his committee was instrumental in helping to, well, requested it, and the UK government agreed, and the UN agreed to help to hold that seminar, decolonization seminar in Anguilla. I do remember going to one or two of the sessions, so dated myself. And in it, we just heard the Minister Hodge read then Chief Minister Osborne Fleming's statement, and there was also a statement read on behalf of the United Nations Secretary General, which he stated, achieving self-government for the peoples of the world has been one of the cardinal goals of the United Nations since its inception. Fast forward to 2006, there was a Constitutional Committee led by Mr. Mitchell that finished its work in 6 months, but again, nothing materialized in terms of anything being adopted. Fast forward again to 2015, and the United Front administration, Mr. Mitchell again was asked, and he agreed to lead the initiative. And then after 2 years of work, a report was tabled and a draft constitution formulated. So what informed that whole process? It could be argued that the Anguilla Constitution, in terms of 1980, the Act, and then provisions in 1982 Constitution, is a constitutional dictatorship in the extent that it provides for a lot of powers for the UK government, including the power to suspend unilaterally the Constitution if so desired. And this is not an idle threat, because we saw that in the TCI on 2 occasions, one in the 1980s and then again in 2008, I believe, the UK exercised that they call it the nuclear option. And so from the consultations, the committee of 2015 to 2017 determined that there was, based on the sentiment from the public, that there was a need to improve the democracy in the framework, especially in the constitutional framework, and to improve standards in public life. So as I said, that would have informed what was proposed in the draft. So going through the actual Constitution, various sections, starting with the Preamble, it states, we as the people of the territory of Anguilla have over centuries evolved with distinct cultural identity and will, which is the essence of an Anguillian. And the feedback we got last week when that was put up, people seem to agree with those words, and that it highlighted cultural identity and being an Anguillan and so on. It further states that acknowledging that the society of Anguilla is based on certain moral, spiritual, and democratic values, including the belief in God, the inherent dignity of the human person, the inalienable right of the freedom of the individual, and respect for fundamental rights and freedoms and the rule of law. And affirming that the people of Anguilla generally have expressed the desire to become a self-governing people and to exercise the highest degree of control over the affairs of their country at this stage of its development. So it's future-looking as well as present-looking. So, again, continue certain segments, Anguilla status. Part 9, section 106, page 55, deals with Anguilla status. And there's an Anguilla Status Commission which can determine the basis of being Anguillan. And there are several provisions, but two are highlighted here. One, that if you have resided for a continuous period of at least 15 years in Anguilla, you're eligible. And item 4, if you're married to Anguillan, has been married for at least 5 years. As I said, the Status Commission has noticed that there seems to be a lot of what's called marriages of convenience. And so this is something that we'd want some advice from the AG's chambers in terms of don't want to have that abused, that provision abused. Last week, the Minister Hodge would have indicated that certainly the provision 2 can be used to help to engender, grow the population, and indicated that we could perhaps have a target of maybe about 25,000 by, say, in the next 10 years, which would be like doubling our population. We had some feedback on that issue. Someone in the Diaspora emailed to say that yes, they understand the pressures of a small population, but they think that perhaps we have to focus on growing and diversifying the economy first, because if people come here, you need to have jobs for them, right? Yeah, so, but we can do both, I suppose. Right, so this we're in the House of Assembly, and so it thought it fit into to mention a couple of things. There's a Part 7 in the Constitution, draft Constitution, which is titled Powers and Procedure in the House of Assembly. So just focus here on the Speaker, and it says that when the Assembly first meets after a general election, or after the office of the Speaker has fallen vacant for any reason other than the dissolution of the Assembly, the Assembly shall elect a person to the Speaker of the Assembly. So the Speaker shall be elected from among persons qualified for election to the Assembly, but who are not members of the Cabinet. There's some there's a viewpoint that so the Speaker is supposed to be a referee, and there's a viewpoint, because right now basically the government administration nominates, and then since they're in a majority, they tend to carry the day and the person. And over the years in Anguilla, you will find that the speakers are persons who are aligned with the party in power. Typically, they have campaigned to help get them in office and so on. So there's a question of whether there should be another way of choosing a speaker. Then there's the question of voting. We saw this happen in the GST, that you can actually come to a position where there could be a tie or whatever. So what happens? When it says that when their votes are equally divided, actually the speaker can exercise a cast and vote. Yeah. But there are other provisions there, so it's well worth looking through. Interestingly, one of the things that is provided or recommended is that there should be various subcommittees, and one that is being proposed is a finance committee of the House, which would meet on things of a budgetary nature. So that means, for example, the whole process of the budget in terms of discussion in the House would start earlier to allow for more work. So that is, I think that's a good, because there's still a lot of mystery and so on of how a budget, what goes into the decisions behind the budget. Okay, representatives in the House of Assembly, that's part 6. Currently, it is provision for not less than 11, but this constitution, draft constitution, is proposed that it increase to 13. There's provision for single island-wide district voting, and that came about because of the amendment that was adopted in May 2019. So the last general elections, that there was a provision for that. So in fact, we have Minister Hodge and two Hodges, Minister Kenneth Hodge and Minister Kyle Hodge. They are here because they proved popular enough to be in those top 4. And this is based on the comments online. This tends to be the top one of the top ones. Electoral districts. We have 7 electoral districts, and we all know that is not an equitable distribution of population. And okay, if there was, it's actually, the difference is stark in some cases. So you have, the smaller districts of like Sandy Hill, District 2 and Western District 7. Then the big ones of Valley South, Valley North, Road North, and so on. And then, given the way the system is, people said, like, for example, you would have read from Minister Fleming. Minister Osmond Fleming was elected from District 2, one of the smallest districts, and then also elected to be the chief minister. So people will say, well, hang on, the District 2 people had an inordinate influence. So it's things like that has given this impulse to say we need to change. And there's also a suggestion that apart from just having a repopulation, that in fact you should increase the numbers to 9 districts. Then there's also been the suggestion that all representatives should be chosen on an island-wide basis. So that's an interesting thing. Then we've also had comments where some people said, okay, you know what, keep the 2, keep elections on a district basis, also have elections on the island-wide, but you know what? Those executive positions, like the Premier and the Minister of Finance or Economic Development or whatever, that you should, everybody in Anguilla should get a chance to say. So each, like there's the parties then who are running, they would have to say who is they putting up for Minister of Social Development. And I've been trying to dig up some of her papers so like we can share, because she had such a influence on what is happening in Anguilla and Constitution. Dame Bernice Lake, I think she actually, my understanding is she favored this kind of election of the executive on an island-wide basis. Then there's also been a lot of the debate about ex-officio members. So the two ex-officio members in the House of Assembly in the form of the Attorney General and the Deputy Governor, and the view is that they should not really have voting powers, or whether they should be there at all. So why this push about representation? And the view is that one of the things to guard against is that you don't have the Executive Council being a rubber stamp. No, sorry, the House of Assembly being a rubber stamp, because in meaning that if the government has the votes, right, majority, what gets decided in EXCO is just a formality. So, you know, one of the principles of most democratic countries is what they call a separation of powers. So there's the executive, clearly demarcated lines between the executive, the legislative, and the judiciary. And earlier I spoke about the House of Assembly. Under the 1976 Constitution, interestingly enough, at that time, the UK appointed representative was called a commissioner, and the commissioner used to be the Speaker of the House. So he had chair of EXCO, head of the House of Assembly. Awesome powers. So you see why people would say that it was, you know, constitutional dictatorship. So some people say, well, the British are tricky, so they removed the commissioner or the governor from having any say in the House, but yet the appointed officials in terms of the AG and deputy governor are still there. So if they are instructed, then, you know, anyway, so lots to think about. Improving standards in public life, very important section. I think this was an area too that was key to the heart of Dame Bernice Lake. Because I remember hearing her talk about that, say, if we aim in, which we should, aspire to independence, you need certain protections, certain guardrails, you know, and they come in the form of what they call institutions of good governance and also persons. So there's recommendation for a number of commissions there, some of which are already in place, some of which are not. For example, we don't have an integrity commission. We don't have appointments commission. So that comes in like when you are dealing with appointments to statutory bodies and so on. We've heard a lot over the years of the need for a Freedom of Information Commissioner, Human Rights Commissioner, Complaints Commissioner, and so on. So very key. And then also very important, because money can be a corrupting influence, and there's an argument that there should be, should be provisions for campaign finance, and that when you should allow the different entities and players to have an equal playing field, and so you don't want let's say big business, corrupting the whole system by campaign contributions. And so that if they're campaign contributions, they should be transparent. And limits to what can be given. Another new area, pretty much for the most part, is in the area of public finance. There's not much provision now, but there's a recommendation that it should be an extensive section. And the UK government had actually, in 2015, had circulated a draft Anguilla 2015 order, which they were considering enacting by an order in council, but they didn't do it. And when we were doing the research, we noticed that order is actually modeled on the TCI Constitution. And the TCI Constitution of the Caribbean Overseas Territories is the most recent. There are a number of provisions, one of which is they said that there should be the negotiation of a new fiscal framework, and there's then repeal of the existing fiscal framework. As the existing fiscal framework covers things like value for money, things like procurement. There's a lot on borrowing guidelines, setting limits on debt, making provision for a rainy day in terms of recurrent expenditure, setting up a capital development fund, and so on. Also noteworthy, there's in the UK side is recommending that there should be explicit provisions of the powers of the governor as relates to this section, which when we compare to the TCI constitution is not there. The UK is trying to justify this by saying, well, throughout the constitution there are lots of powers that are given to the governor, and so we're just making it explicit. So I think the drafters, the legal people, the AG's chambers have to ensure that government of Anguilla is not unwittingly devolving, giving up authorities that have been devolved. Power of the governor, moving on, most of the key powers remain. The 1982 Constitution, as I said, actually removed a lot of, it was quite, before there was a greater element of what is called internal self-government, and that has been a gradual deterioration from the associated statehood. Because as I said earlier, associated statehood was seen to be a halfway house to independence. The only areas that the UK government had responsibility for were for external defense and foreign affairs. So the UK government, they have maintained that as long as a territory stays in a relationship with them, they are subject to various international conventions and obligations, so they have to ensure that they are lived up to, both, and also that there should be maintenance of good governance, and the government of the UK has to ensure that they are not overexposed to contingent liabilities, because if a territory goes bankrupt, the UK is legally obligated. And we saw again in the instance of the TCI in 2007, they reached with a situation where they hit the wall and they just couldn't meet their obligations. And the UK government ended up providing what is called debt guarantees. So it allowed them to go to TCI government to go to the market and raise funds at a cheaper rate. So that's the line from the UK standpoint. The executive, part 4, authority rests with Her Majesty and it's devolved. So there's a UK appointed governor, there's a cabinet. Well, the proposal is that what is now known as Executive Council be renamed as cabinet, and it should consist of the Premier, who used to be known as Chief Minister, not more than 5 other ministers, 2 ex officio members in the AG and the DG, you shall vote. And Her Majesty is represented the governor, who does not vote and who chairs. Protection of fundamental rights and freedoms, part 1. Again, this section is quite extensive, and we just chose one example. But again, what the UK has said is that they are being subject to these various conventions. They have to ensure that they're lived up to. And for example, in this section, protection of right to marry, the Anguillan view is for a certain language which views marriages between a man and a woman, really. And the UK is saying they prefer that there be no such distinction because that would be discrimination on the basis of sexual orientation. So they've And the negotiations here in 2019 and also the town hall meetings, Anguillians were quite forceful in that they, again, the culture, the traditions and religion and so on. That's how they viewed marriages between a man and a woman. So the UK has offered a compromise where basically the issue would be settled in an act, the Marriage Act. So I don't know if that gets us out of it. Yes. The question of independence, this was posed during the negotiations, and one of the participants on the Anglo side was of the view that there should be an explicit reference in the Constitution. But the UK said, well, everything, and if you go online and you Google or if you print off the Constitution, this draft Constitution in 1982 and so on, everything actually makes reference to the Anguilla Act of 1980. And so the UK government said in the Anguilla Act of 1980, there's provision there for if the Anguilla people opt for independence, then it can be triggered. So amendments, I mentioned there are some amendments made in May 2019, and so mentioned those before. Change from Chief Minister to Premier, change to have island-wide voting, 4 members, for election of 4 members, and then the change of to allow for people who are great-grandchildren of persons born in Anguilla to become Anguillians. So we've seen a lot of that. Yes, I'm on the Anguilla Status Commission and so on. But it's actually automatic because it's language. They don't need this commission to meet on that. Once you can do the due diligence and these people have the requisite documentation, they can show that they're great-grandchildren. They're granted. So, to conclude, 3 questions. Do the proposed, so going back, you remember there was an earlier slide that says there are 2 things driving what the committee was trying to do based on the feedback. Basically to try to increase the level of democracy in the framework of the Constitution, which, as the Premier says, the Constitution is the supreme law of the land. Do the proposed changes satisfy the demand for improved standards in public life? And then, as sort of a catch-all, are there any other principles of note or provisions which the general public would want to have reflected in the Constitution? So that's it, and as usual, we post our email addresses there, and again, just to say thank you for those who have been emailing us. We have taken note of your comments, and in fact, we've referred to some of them here tonight, and so thank you. Keep them coming.
Thank you, Dr. Harrigan. Before I open the floor for questions, I just wanted to make a comment about the Appointments Commission that Doc referred to earlier. I know traditionally we have seen the practice of governments over the years appointing their supporters to serve on boards. The question here, is this the best practice? Are these appointees sometimes the best qualified? The Appointments Commission would certainly take the political side of it out. And I know over the years, some institutions have instituted programs of certification for their directors, and this administration would have made it mandatory since coming to office that all members of boards be certified. So these are the kinds of questions to think about as we go through this process. The floor is now open. Mr. Kentish, I see you ready to go. Let's put on the mic.
Good evening to everyone. Let me start off on 119, public finance. Accounting. Currently, and Dr. Eden, as someone who has worked in this area for someone, you can probably comment. I think we currently engage in cash book accounting, right? And I think it's time for that to be abolished. There are weaknesses in the system. This allows for a Minister of Finance to stockpile invoices at the end of a financial year. And you can either present an artificial surplus or a real deficit, right? And this possibly has happened over the years by governments. But I will point out a practical example of this. And this is found in page 15 and 16 of the Mark Watson report of May 2010, which Dr. Aidan Harrigan is most familiar. And for the benefit of the listening public, I'll quote. Recurrent expenditure in 2009 was EC $204.17 million. Marginally lower than current expenditure of EC $209.5 million in 2008. However, that excludes EC $14.25 million in unpaid invoices, including Anguilla Social Security Board, EC $6.88 million benefit payments, Civil Servants Pension Fund, EC $1.57 million pension contributions, ANGLEC, EC $1.3 million utilities. It continues. These arrears must be paid in 2010 and make it even more difficult to balance the budget in 2010. If these were included in the 2009 outturns, this would reflect the true expenditure of EC $1,218.42. On this basis, the real budget deficit in 2009 was EC $70 million, or 47%. That is precisely the kind of thing that we ought not to have happening in this era. The question of accountability must arise. So that goes on to what we probably, I think they call window dressing. Making the accounts look good, the finance minister sticking the it's probably it. Yeah. Yeah. It just went off. Okay. It's on. Okay, and this could happen particularly if at the end of a financial year and next year there's an election coming. This could give rise to this practice of stockpiling invoices and not accounting for them. So we have to move away from cash budgeting and into a proper financial system where we do making provisions and this sort of thing, and more and being more responsible. In this regard, I am proposing that a section be included titled the Fiscal Responsibility and Taxpayers Protection Act. Dr. Eden, I shared this document with you some time ago. And this is an interesting document, and it's currently in operation in the province of Manitoba, Canada, right? And this brings into the realm of fiscal responsibility and accountability on the part of ministers of government now. Whereas you guys have the privilege of going in the House, you pass the budget, and at the end of it, that's it. You spend as you wish, and there's absolutely no accountability. Now, this act as it is, and it could be, I'm just suggesting as a thing, it could be modified to suit Anguilla's particular circumstance, right? This now requires budget and fiscal responsibility. This now requires the Minister of Finance to table a budget by a particular date of the year, whether it's by the 15th of December or what have you. And additionally, he has also to prepare a long-term strategy, a plan of how he's going to achieve the budget, as well must be filed along with that. So then he goes on. A section maintaining a balance. It says government not to incur deficit after deficit eliminated. The government is not to incur a deficit for a fiscal year after, and it goes on to that sort of thing. It also provides how you are supposed to calculate the deficit, right? And we go down here, and it has a section, Ministerial Accountability. And this is the section which now, I believe, legislatures will balk at, because this is where it's going to affect you guys when it comes to responsibility of how you disperse taxpayers' funds. It says ministerial salary means the additional salary otherwise. I'm not going through all of it. Payable to minister under the Legislative Assembly Act for services as a member of the Legislative Executive Council. Then it goes on. 20% of ministerial salary to be withheld. Subsequent to subsections 3, 4, whatever it is, an amount equal to 20% of the ministerial salary and otherwise payable to a minister is to be withheld pending the application of whatever it is applies. But it goes on, and this applies to where you are going into deficit. When a minister is going, the finance minister is going to deficit, there is now a penalty. 20% of his salary is being withheld until he files a report in the House of Assembly outlining the position of the government. And that has to be justified before he can get that 20% paid to him. This now produces an essence of responsibility and accountability on you guys as legislators for the first time. We are moving into an era of accountability, and this is what we are demanding from our electors or the persons that we have elected. This here helps to provide that measure of responsibility and accountability. And another section, I think, let me see the two. You want me to? You go ahead.
Right, so the point you make about expenditures and so on is a good one, and I know this has been under discussion for some time. Currently, the government of Anguilla operates in what's called cash accounting, and the recommendation is that you move to accrual accounting. It's a bit more involved and requires, some expertise in the various units and so on. But that would allow, a multi-year perspective, and so it would facilitate, because as you mentioned, you can have expenditure that is incurred, let's say in 2020, but if the bills are not paid to 2021, it doesn't show up, but it's a liability. It's an obligation. So I think that needs to be addressed. So the legislation from Canada is a lot about balanced budget, and there is some movement towards that in the proposed constitution. If you look at section 119, subsection 7, it says the government shall aim towards achieving and maintaining a surplus budget, and where an appropriation bill would not return a surplus result, the Minister of Finance shall at the same time as the bill is introduced in the Assembly, lay before the Assembly a statement explaining the reasons for not achieving a surplus. And so it's not hard and fast as the Canadian one, and I think the U.S. used to have a balanced budget provisions, but that's something for folks to consider,
Nowhere in there,
Yeah.
nowhere in that proposal there, I see any measure of
But there's no sanction. Right?
no sanction.
No. That's
And as a member of the public,
Yeah.
I want to see we would like to see sanctions now. Because you pass laws that tax us, right? You know, and then you can go and spend our taxes as you wish without any consequence. We are saying no. The time has come for accountability. And in that section, 119, we want to see penalties in there. Ministers of Finance must come now responsible for how they dispose taxpayers' money. We want value for money. Another important, interesting section of this act, Taxpayer Protection.
That's the Canadian one?
Yes.
Yep.
Yes. Referendum required for tax changes. The government shall not present to the Legislative Assembly a bill to increase the rate of any tax imposed by any act listed below unless the government first puts the question of the advisability of the proceeding with such a bill to the voters of Manitoba in a non-binding referendum. And such acts are, it says, the Health and Secondary Tax Levy, the Income Tax Act, the Retail Sales Tax Act, And that, in our case, would be the GST, the goods and services tax. So we are saying here, we need that kind of protection as well. Equity, some sort of equity in the system.
Well, the question of referenda for important, for tax initiatives, that is a very interesting concept, and people would say, well, yeah, it's democratic because
It's democratic. We live in a democratic society.
Ultimately, it's the public will have to bear the burden or whatever, so they should have a say. And it's quite common in the U.S. as well. The state systems, you know, in California you hear about proposition this, proposition that.
Presently, as for example.
Yeah.
Tomorrow, if the government wishes, it can go back to the House of Assembly and increase the GST to 15%. That's permissible right now. And we, the public, have no choice but to accept it as law. So we are saying here, let us have some discussion on these particular serious issues which affect our pocket in these very difficult times.
So this Constitution does provide for people-initiated referenda, and so it just be a matter to determine whether that is sufficient. In page 38, section 66 of the Constitution, page 38, section 66, it says people-initiated referendums. Without prejudice to section 65, a law enacted by the legislature shall make provision to hold a referendum among persons registered as voters in accordance with section 69 on a matter or matters of national importance that do not contravene any part of the fundamental rights provisions or any part of this Constitution. Before a referendum on this section may be held, there shall be presented to the Cabinet a petition signed by not less than 25% of persons registered as voters in accordance with section 69. The Cabinet shall settle the burden of a referendum question or questions within a reasonable period as prescribed by law, and the Cabinet shall determine the date of the referendum, and the referendum should be held in a manner prescribed by law. Subject to this Constitution, a referendum under this section shall be binding on the Government of Anguilla and the Assembly if assented to by more than 50% of the persons voting in the referendum. So then, of course, you can have it to be even more specific, to say relating to tax laws and so on and so on. So there's an opening there for you.
It's open, and we want it to be specific. Let there be no misunderstanding when it comes to this issue of taxation. Let it be specific.
Yes. You have anything, Mr. to say? You have any comment?
Okay.
Thank Mr. Kentish for his comments.
I don't know if he's finished, but...
Oh, you haven't finished. Sorry, sir.
Okay.
Sorry. You go ahead.
Marriage of convenience was mentioned earlier.
Right.
And it is, I think, a view that something should be put in the Constitution pertaining to marriage of conveniences.
So maybe I should add a little bit more. Before, right, what used to happen is that when the folks came before the committee, they had to prove that they were still married and basically a couple. Now, the advice we receive is that no, you don't have to prove. You don't have to show. You don't have to be in a married. Well, even okay. So the marriage may have broken down. You're not divorced, but that doesn't prevent you from putting in your submission. Then in that you qualify.
Well, and then it has all sorts of ramifications in terms of whether before it is consummated, sometimes persons may pay huge sums of money, and a big altercation ensues as to, right? So some sort of something should be put in the Constitution on the issue of marriages of convenience. Well, on the legislature, I had some thoughts in terms of whether we have a law house, the executive, as opposed to the legislature. The executive then deals with the day-to-day running of the government. They propose the laws, etc., and then it is the legislature which then passes those laws, debates and passes those laws. So we can probably look at maybe increasing the size of the persons being elected, and the upper house, those members could probably would be persons who are maybe actively employed and paid on as they meet for those sessions. That's one of my contention views here. Section 78. Yeah.
You know, there was a suggestion made that we should increase the House at least 21 members. That was the suggestion.
I actually had 23. 13 for the legislature, was it? And was it 13? 13 for the legislature and 9. I can't quite remember what was my configuration right now. But I had more in that ballpark, in 21, 23, 3 figure. 78, summoning of persons to assist assembly. It says here, the speaker or person presiding may, when in his opinion, the business before the assembly makes it desirable to summon such a person, right? It is, I feel that if any member of the assembly wishes to summon somebody who has the expertise to make a contribution on the particular bill that is being debated, I feel that that member should have the right to have the speaker summoned, and in that case, where the word may, I suggest shall. The speaker or person presiding shall so that that person, that member of the House of Assembly may have the support of the person, that professional who can help to add clarity to the bill, right? we go to 86 privileges of the assembly and members. Gentlemen, I am privileged this evening to be standing in the People's House addressing you on constitutional review, right? But it says, a law enacted under this Constitution may determine and aggregate the privileges, immunities, and powers of the Assembly and its members, but no such privileges, immunities, and powers shall exceed those of the House of Commons of the United Kingdom or its members. I don't know, Don, you can help us with any of these privileges. But before you come, if you have the, right? My observation, gentlemen, you are given the privilege by the people to enter this honorable house, to pass laws on behalf of the people. We expect that the level of debate ought to be pertinent to the relevant bills. Over the years, members of government have used this honorable house as their bully pulpit to launch scathing attacks against ordinary Anguillians. And what is so funny about it is you are clothed in immunity. Some by their posturing, the maligning, the innuendos, the degradation of people's professional integrity. It happens right here in this house. We didn't elect you for that. Members of the public, we have no access to such immunity. On the talk shows, let any member of the public dare to defame any minister of a government. And he or she then uses his right properly to instigate civil proceedings for damages. Where is the equity? The ones in here must either be statesmanlike, in consistency with what we sent you here to do. Debate in a civil and respectful manner, and not the defamation and degradation of citizens who don't have the privilege. And I won't advocate that we want to come back in here and have the privilege of responding. That is not national development. we expect civil discourse in what is supposed to be referred to as this honorable house. So, if and when I'm proposing that if such instances occur, the ordinary citizens are attacked in this House of Assembly, such instances be referred to the Integrity Commission for investigation. And if found guilty, penalties, and I'm only suggesting one, 80,000 EC dollars upwards, be imposed on that member. We are serious. This must stop. And where a speaker permits this conduct to continue, that speaker too must be referred for censorship. The Integrity Commission. And lots of commissions are coming forward. As part of the institutions of building capacity to prepare us for self-governance. Long overdue. Provisions have been made in the law for the commissioners to make the necessary research for the provisions to include in how the commission should function. I have looked at the Bermuda Integrity Act, and I would suggest that that is one that can be looked at. It has sections in it like bribing members of the Senate or the House of Assembly, bribing other public officials, bribing relatives and friends, and these include a parent, a child, a sibling, spouse, a partner, uncle or aunt, niece or nephew, cousin. The whole gamut is involved. It also addresses the abuse of office. And there are also penalties in there. They go so far as in that Constitution, if found guilty, it involves something like 14 years imprisonment. I am not suggesting that is for the commission to investigate and make its decisions as to what sort of penalties to be imposed. Right? Let's see if I have anything else here. The Anguilla Status Commission. I know, Honorable Minister Ken Hodge, you, in one of your presentations, I think you were suggesting that the period from 15 years be reduced to about 12, right? In many other islands, they have a number of years. They have decided what years they would stipulate. In our review, I may suggest that we look at a period of between 7 to 10 years as there are persons, or Caribbean brothers and sisters, some of them come here, many of them come to our shores, and many of them decide to stay, right? And we're looking how things evolve. People, how they would like to get themselves established in Anguilla, how difficult it is for them to get established. And we can do things to help to facilitate. We too have traveled. Our history is one of traveling to other people's country to make a living. And here, I am suggesting that the period could be shortened to between 7 to 10 years. In recognition, and we have, quite recently, we have the fantastic gesture of the St. Lucians, who have provided free labor for the repairs to the public market. That's a good indication of people integrating into a society and recognizing an obligation to contribute. I applaud them. I will just, we have the appointment, the power to appoint to offices. We have the Police Service Commission and this sort of thing. But it provides for all these commissions where you will have, now going forward, I would think, persons with the requisite experience and qualifications and skill sets to fit on those commissions. But one of my concerns coming out of reading this, when we put our professional Anguillians on these commissions to function, and you have in our legislation things like this: governor acting in his or her discretion may not otherwise than in accordance with that advice, if he or she determines that compliance with that advice would prejudice Her Majesty's service. When I read that, that pains me. That is an insult to our intellectual people serving on those commissions. That's an insult, in my view. It's humiliating. It's disdainful. So how are we to prepare to make decisions and to grow when you have this overreaching and overarching power over you all the time. In fact, Putin, Erdogan, and what's the guy in Belarus, the strong man in Belarus? They'll be happy with these kind of clauses. They'll be happy. They're dictatorial. And you used the phrase earlier. It's a dictatorial relationship. That's how strongly I feel about these kind of wordings here in our Constitution. It's an insult to our intellectual capacity. We are elevating the governor as being infallible, incapable of making mistakes, imperfect, perfect. But the people, our people who are providing advice based on their experience, this can be dismissed. That galls me as an Anguillan. That hurts me to the core. Gentlemen, that is my contribution.
Mr. Kentish, I just want to thank you for your in-depth presentation. You covered a lot of topics, and you can be assured that we have it captured on tape, and we will be reviewing your presentation again. So thank you very much, sir, for making that contribution. We have Mr. Connor in the back. Yeah, we are now 10 minutes to 8, so we're going to, yes, come, Mr. Connor.
Okay, good evening. The first thing I would like to say is that with respect to health, we have one person right now who is really dear to my heart, who has passed of cancer last Monday. Her name is Terry. She passed of cancer. And the thing about it is that I did a course with Howard University. And what they indicated is that if somebody, for example, a family has cervical cancer, a mother has cervical cancer, then those cells can be harvested. And then an electrophoresis procedure can be done. And after that mother is good, then you look towards the daughters. So like 2 years after, you go back and you check the daughters to make certain that everything is okay. In Terry's case, Terry was a physician assistant in the States. She was born in St. Thomas and her mother was from Anguilla. At 65 years, okay, the point I'm trying to make, though, is that there's a particular program which deals with mesothelioma. And that particular program, the companies that produce asbestos had to put a fund, and that particular fund came up to $30 billion about 3 to 5 years ago. When I checked, $5 billion had been spent and $25 billion is still available for communities like Anguilla, who might have sent kits, who might have patients, cancer patients. Because of the fact that asbestos has been used like in the pipes, you notice that the water probably comes out and somebody in a community or in a home might use the water and that might initiate cancer. Okay, so many of our people, for example, my sister died of cancer, but she spent $250,000 in New Jersey. So basically what I'm saying is that we should be in a position to look out for Anguillians in certain areas. One, as far as the energy is concerned. Two, as far as cancer is concerned. Okay? And as far as the energy is concerned, I think the headquarters is in, I'm not certain if it's not Berlin, but anyway. They had about $94 billion in that particular fund. Because of the fact that we are always using gasoline, and the gasoline produced carbon monoxide, which is CO, and the oxygen, you need to have 2 atoms of oxygen to make it stable. But the emission is only 1 atom of oxygen. So when that 1 atom of oxygen is emitted from the car and it goes up, it passes different layers in the atmosphere. You've got all the way up mesosphere, ionosphere, but when it reaches the ionosphere has 3 atoms of oxygen that protect the Earth from the ultraviolet rays of the sun. And when this carbon monoxide goes up, because there's a deficiency of 1 oxygen, it takes 1 oxygen from the ozone and leave it with O2. So instead of O3, you have O2. And the O2 cannot filter the rays of the sun. So you've got the rays coming down, and that creates cancer. So for example, you might notice that some people, like for example, you know, our people in the Caribbean may not suffer as much. But when you see other people and you see the scales on the hand, it means that, you know, they might have been exposed to this ultraviolet light from the sun. But the point I'm trying to make, though, is that you have $25 billion for mesothelioma. You have another $93 billion for energy or carbon products that might hurt the atmosphere or hurt the people. And Anguilla has to be able to identify those funds and be able to participate in them, because some of these things can be extremely expensive. Or people might have to go to Colombia, and not everybody might have that opportunity or that wherewithal to go to Colombia, you know, financially. So we have got to be able to look to see exactly where Anguilla falls, and even though the United Kingdom would be in charge of the external affairs, they would have to determine how much Anguilla should get from those particular funds. So for the mesothelioma, I've got this document for mesothelioma, and with the other one, I don't really have the documents for the energy. But the point I'm trying to make is that we have got to be on the top of it. And we have got to make certain that all people are protected, particularly when it comes to health. Another thing with health, another thing I would like to point out too, is that we are supporting the economy of the United States tremendously. And there are certain programs that the United States has, particularly with the 242 program, which we should be able to participate in, and do not limit the type of medical facilities that we would have locally. Okay, so I thank you for that. And the last one I would like to leave with you is the Federalist paper for 7th of March, 1788, by Alexander Hamilton, which basically indicates that a tribunal in the Senate can be formed to take care of certain things that otherwise cannot be taken care of. So I'd like you to look at these two.
Thank you very much, sir. Mr.
Thank
Connor,
you.
thank you very much, sir. Yes, Mr. Kentish?
Thank you for just one more point. This, I think, is the Public Accounts Committee. I would like to suggest the yes, it is on. I would like to suggest the broadening of the composition of the Public Accounts Committee so that you have incorporate more people with wider perspective than just from within the House of Assembly to deliberate on it. That's my perspective. Another aspect of it would be to allow, when they're having their sessions, to allow members of the public to pose questions. It's our interest.
There was a section that you referenced, so we'd have to see if under that provision whether, but
Okay.
maybe.
Okay.
We'll
I
have
just
check
want
into
to.
that. But questions being asked by the public to that is, I think I don't see any reason why it couldn't be allowed. They could write, if it's published to say that the PAC will be having a hearing on, say, Social Security, there's no reason, I don't see any reason why the public can't submit questions that can be considered,
Also attend and ask questions as well. It's our tax dollars, and I think we should have that right.
But the Public Accounts Committee is a creature of the House. It's a creature of the House. The Public Accounts Committee is a creature of the House. Yes, yes.
Well, maybe I am a creature of something else, which says that creature should change in 2021. That creature needs to evolve with the times.
Take your point, sir.
Thank you kindly.
Thank you. Mr. Mitchell, you want to share a few closing thoughts?
Thank you. One day I hope to see it in writing, perhaps when things are published, because it's hard to take in a lot of new stuff, especially at an advanced age and at a late hour of the evening. 2 points of Mr. Kelsick, Mr. Kentish, came immediately to my attention as being easy to deal with. That is on the question of defamation in the House of Assembly. That, of course, has long been covered by the rules of procedure in the House of Assembly, what will in future be called the standing orders of the House of Assembly. It's really a matter of how strong the Speaker is and how educated in parliamentary procedure the Speaker is, because we have had the rule against defaming members of the public by members of the House of Assembly ever since the House of Assembly rules were first created in 1976. But if the Speaker doesn't enforce them, then there's really nothing that can be done. The rules are there. It is not allowed that any member of the House should defame members of the public. But there have been many cases, as Mr. Kentish has told us, where that has happened due to the negligence or the malice or the lack of attention to duty of a speaker who doesn't do what the speaker is supposed to do. On the privileges of the House, I have a little note here to make a comment on Mr. Kentish's point. Don't really remember now what the point was, though. I work better when I see things in writing than trying to remember things that I hear at a late hour. I did want to talk about it, but I don't remember what it was any longer. Basically, I suppose I should explain that the reason why I come to every one of these meetings is that I view my role as being to defend the draft. This draft constitution consists of two inputs. It started off as the Anguillan public input. The first draft was what Anguillan people wanted. Anything brand new coming out now is something which was either rejected by the Anguillan public before in the earlier consultations or was not proposed for Anguillians to be able to comment on them for us to know if it is something that has widespread support. And I'm really only interested in pushing for those issues that Anguillians gave widespread support to. If you ask me, I could come up with plenty of new suggestions that I would like to see in a constitution, but that is not right at this stage. The second input, of course, is the British, who have looked at the Anguillan suggestions and have said, well, all right, in addition to the things that you want, there are certain international treaties and conventions and obligations that we must make sure that you comply with. So we are going to put into your draft things that we believe are essential to be in there because we are responsible for making sure that you meet certain minimum standards in your constitution. And so they've made their suggestions. Some of them I don't agree with. And in due course, I will, if I get the opportunity to deal with the British, I will make my views on those points clear. But I recognize that they have a different agenda to ours. Ours is to increase democracy in our constitution and to try to achieve the highest possible standards of integrity in public life so that when the time comes for us to consider becoming politically independent, we will have seen our senior civil servants and our ministers of government and our public officers holding to high standards which will make us confident to put our treasure and our lives into their hands in an independent state. We aren't there yet. We aren't there yet. We have a constitutional system that is most unsatisfactory. And it is my belief that this draft carries us forward to a much higher standard of governance. And I'm keeping on coming in an attempt to ensure that nobody whittles those standards away. That's all I'm interested in. Thank you, Mr. Minister. Sorry? Which immunity? Yes, well, the Premier asks whether I can say a few words on immunity in the House. There is no doubt that it is a fundamental principle of constitutional law that members of the House of Assembly must have immunity to express themselves freely without any fear of any litigation being brought against them when they're discussing the public interest. Nobody should be able to stop them or to interfere with them. The Speaker will insist that they follow the rules, and the rules are limited on what you can talk about. For example, one rule is that you must stick to the issue that is before the House for debate. We have known members of the House in previous years talk for 3 days on all kinds of stupidness that have absolutely nothing to do with the bill which supposedly is being debated. But if the Speaker is uninformed, uneducated, ill-prepared, and doesn't know how to insist that the item, that the remarks that are being made are relevant to the topic as the standing orders or rules of procedure insist they should be, then there's nothing we can do about it. So the immunities of the House are an important principle because the members of the House who have been elected to represent the interests of Anguilla must be free to make their opinions clear and to express themselves on the relevant issue that is before the House. They shouldn't be whittled away. The immunities should not be whittled away any more than they already are by the law and the Constitution. If a member of the House of Assembly was to stand up in the House of Assembly and threaten to commit murder or threaten to assault somebody, that is already illegal. We don't need to do anything special to provide for that in the rules. It is already clear that the Speaker must stop that instantly. And if the Speaker doesn't, then what can we do? There's very little we can do because the Speaker is then not performing his or her duty.
Yes, thank you very much, Mr. Mitchell, Justice Mitchell. Premier Ney, final closing comments? Are you good? Okay. Doc, I just want to thank members of the public for joining us here this evening. I just especially want to thank all of our presenters here this evening. Dr. Aidan Harrigan for his inspiring presentation, and those in the audience for making their presentations. Honorable Premier, the Honorable Minister, Mr. Kentish, Lawyer Don Mitchell, and of course we have gotten some questions coming in as well, so we're going to collate those and present them sometime before the end of this series of consultations. I want to thank our capable man of the hour, Mr. Gaff, Titanium Sounds in Anguilla, for excellent job as always in putting the audio, visual, and streaming together. Thank Radio Anguilla for carrying this session live. Thank the speaker for the use of this hall for this evening, and thank our listeners across the various platforms. And of course, even though this has finished, you can still view it and send in your questions and comments to us at the ministry. Thank you all very much and have a safe drive.